Hello, everyone. Welcome to this beautiful morning here in Stockholm. And hello, everyone online. Welcome in joining us into this one of the investment cluster events with SWEAC, and today together with European Union Intellectual Property Rights. I will start just telling just information about security. If anything happens, any burning signs, this is the way forward to get into safety. We will have a tight agenda, and I will start welcoming my nearest colleague, the chairman of SWEAC, Joachim Davidsson, for the welcoming remarks.
So, good morning, everybody, and welcome to this special event together with our friends from EU IPO. SWEAC, as a chamber and organization, of course, we have focusing on business in Africa with a focus on East Africa. Part of our work is clusters and cluster development, and actually today is the sort of event together with the investment cluster, which Heaven is managing for us inside SWEAC. So I'm going to show you a little bit presentation of what we are doing inside SWEAC. Very good, it starts automatically. So our sort of slogan, what we want to do, is growth and knowledge through collaboration. And this is very important for us because we feel that our assignment is matchmaking and facilitating. So we are helping as much as we can to the Swedish companies and also educating them of a business opportunity inside Africa, in East Africa. So clusters for this year, 2024. What we do, we have an ICT cluster, healthcare, agri is under development, and especially because of last year's conference, where a lot of East African companies are looking for agribusiness in Northern Europe, which is very understandable, but not so easy, as our food and agri sector is very industrialized here, meaning that the players are big size and the sort of sellers, producers in East Africa are small. So not so easy to do good matchmaking, but we are working on that. Green City is also a cluster where we do a lot of focus on sustainable business. It's energy, water, waste, and this is actually where we see the most of actual business between at least Sweden and East Africa, that we are able to develop good projects for clean tech and green tech in Africa. Part of that is also, of course, companies like Scania, who provide sustainable transport system, but can also be the facilitator for other green and sustainable project for Swedish companies. And investment is a cluster that we are working and doing matchmaking between angel investors, companies, and sometimes also service providers that we have in Sweden, some from government, some from private. Why focus on a cluster? Well, neighbor value. Because just belonging to a big chamber of commerce, attending meetings where we talk about two generalized items is not especially beneficial for certain companies. So that's why we have make them talk about healthcare or talk about clean tech or talk about investment. So member focus is an important part of it. Then we have, of course, cooperation, and we want to develop as much cooperation as we have. We are working with our counterparts in East Africa, KEPSA, for example, in Kenya, TCIA in Tanzania, PSF in Rwanda, and PSF in Uganda. We're also working with UNCCI in Uganda. All of them are Chamber of Commerces, but from the region. And this is also something, we are not trying to do everything in Sweden, but sometimes we are working together. And this last years where more and more meetings are hybrid, like this one. We can have a lot of the people attending our meetings, but from the region, which we feel is quite good. Better intelligence, yeah, we need that. We need to understand more about Africa and the conditions of Africa. And today is a perfect place to learn a little bit about intellectual property rights and legal issues that might occur when you want to do business in Africa. So that is also very good. And then we as a chamber are member of EBCAM. EBCAM is a pan-European network of chamber of commerces. So we have counterparts that like SWEAC, but in France, in Germany, in Italy, in Spain, in Greece. And all of us in total are 4,000 companies working with Africa in one way or another. So sometimes when we have a big project, for example, energy could be, maybe 30% of the projects can be found in Sweden, and then we can go to EBCAM members to look for somebody else, maybe a partner in Spain, maybe a partner in Italy, maybe a partner in Germany. And this is something that we're trying to do more and part of member value as well. So what we're trying to do with our cluster work, with this kind of cooperations with others, is of course developing projects, real business for Swedish business. And to our help, you can have legal support, you can work with a local chamber, you can work with different clusters, and we are also developing collaborations with so-called EPCs. EPCs is a company who will be a project leader. For example, Kenya government come to us and say, we are looking to build 3 new hospitals in Mombasa. This is a big project, what can we do? So then we can find an EPC in Sweden who can big enough to take on a project for 200 million, 300 million euro, etc. And then divide it by Swedish companies and maybe EBCAM members from Germany, France, Italy, etc., depending on the project, the nature of the project, and what kind of facilities or technology these are looking for. So identifying projects and gather the stakeholders, this is something we are doing. And very often we arrange these kind of roundtable discussions in Sweden, where people from the financial part, the technical part, the service providing part can sit down and talk about, for example, if we are going to build 3 new hospitals in Kenya. So this is just a picture of some of those matchmaking sessions or conferences we are doing. This is a big part of our work. We are not involved in too many of when it comes to delegation trips, but we are very much focusing on matchmaking and conferences where people can meet and people can teach each other and learn from each other. So part of this matchmaking is a conference, as I mentioned, SWEAC Business and Investment Forum. We do this every year. Every other year we have done it in Africa. Every other year we have done it in Sweden. We are talking to focus in on Africa only. So for this kind of conference. So in Sweden, we are going to focus more on cluster meetings, smaller gatherings. But in Africa, we will try to do a little bit bigger conferences as we've done. This is a picture of 2020 when we were in Dar es Salaam. We had a very, very good conference. Too bad this was in March 2020. And we just had to fly home quickly because all of the airports were closing down airport by airport. And since then, of course, it has a little bit slow start to enter and restart a lot of projects. But it was a good conference and a lot of things happening. 2 years later, we were in Nairobi in Kenya and arranging a conference. And of course, last year we were in Sweden. Next year, or this year, we will be in Uganda. But after that, we were focusing on being in Africa only for this conference. So SWEAC Business Investment Forum this year will take part in Uganda, in Kampala. And I hope to see some of you or all of you in Kampala. We will do this after summer in the fall. But I can also inform for those who are interested that in between March 5 and 7, we have our partners in Kampala, PSFU. They are helping EU with the Uganda EU Business Forum. This is going to be a big event in Kampala, 3-day, where they're going to be some exhibitions, workshops, of course, speeches, and overall a lot of business matchmaking. And I hope that this is something that many of you can be with or come with us to. And besides that, I hope that for those who are not members with us so far, that you can consider joining us for working inside SWEAC. SWEAC is, of course, focusing on the EAC, the East Africa Community, which is sort of a smaller version of EU, but only focusing on East Africa. The key members are Kenya, Rwanda, Tanzania, Uganda, but also Burundi, South Sudan, and lately Somalia has joined the EAC, and also DRC, Congo, is part of the EAC. So all of them are welcome to be a part of the EAC and the SWEAC. Our cluster work is, I should also inform, are Pan-African. So sometimes we have other countries besides the EAC members attending and joining our cluster meetings, which they are all most welcome, because it's all about finding opportunities for Swedish companies in Africa and developing trade and investment. This is the task for the Chamber of Commerce. Facilitate, helping, sharing knowledge, sharing networks, sharing contacts. And we are very happy to see all of you here. I want to especially also thank my colleague, Heaven Berket, for arranging this, all the logistic and all the facilities here, very good. And I want to thank our friends from the EU IPO who have come here today. You will hear them speak and you will learn from them. I'm going to learn from them. I know a little bit about IPR, but I need to learn a lot more about IPR in Africa. So I'm looking forward to that very, very much. Okay, thank you. I think I stopped there. And hopefully I'm following the time fairly okay. Okay, very good.
Very happy. Thank you so much. Yes, we do like to supporting building the bridge between Europe and Africa, especially doing more business together. So thank you, Joachim. And now, Alberto Russo, the floor is yours. Please welcome you from the European International Property Rights and one of the experts. Is there anything more you want to tell us more about you?
Well, good morning, everyone. It is a real pleasure to be here this morning. About myself, well, I'm a project officer for the Europe Africa AP SME Helpdesk on behalf of the European Union Intellectual Property Office. In the next few minutes, I shall present you the our service, the Africa AP SME Helpdesk. Indeed. Yes. Can I have the following slide, please? Oh, yes, indeed. Okay, thank you very much. Okay. The Africa IP SME Helpdesk is a service offered by the European Union Intellectual Property Office, focusing specifically on IP and targeting European Union small medium enterprises wishing to invest and do business in Africa. Before starting my presentation, I would like to present you a few very interesting data from the Intellectual Property SME Scoreboard, kindly prepared by my colleagues of the European Observatory on Infringement of IP Rights. 99%, actually, the vast majority of businesses in Europe are actually small, medium enterprises. Out of these, surprisingly enough, only 10% have registered an intellectual property right, actually own a registered IP right. But 93% out of this 10% declared having had a positive impact on their business thanks to the registration of an IP right. Then slightly less than half have actually sought financial gains through the registered IP assets, and 36% declared to have succeeded in their business thanks to the registration. What do these data tell us? Well, first of all, that registering an IP rights gives a competitive advantage to businesses in general, not only European and not only SMEs, of course. And secondly, that services like our Africa IP SME help desks and the other help desk I shall talk to you about in the next few minutes, have that there's a potential for such services to target not only the 10% that has already registered an IP right and offer other services, but also the remaining 90% that hasn't registered an IP right yet, because maybe they don't know how to. So, following up. The Africa IP SME help desks belongs to a network of 6 help desks entirely financed by the European Union and specifically focused on regions in the world. These are Latin America, Europe, India, China, Southeast Asia, and Africa, of course. The Africa IP SME Help Desk is the only one directly managed by the European Union Intellectual Property Office under EU mandate, of course. So what is the Africa IP SME Help Desk? How does it work? And under which framework? As said already, the Help Desk is a service offered by the EU IPO, having its seat in Alicante on the Mediterranean southeastern coast, targeting EU SMEs, small and medium enterprises wishing to invest in Africa. The Help Desk is an EU-funded project implemented by the EU IPO, targeting EU SMEs and working under the scope of AFRIPI. You will see the logo here on the right. AFRIPI is an international cooperation program focusing on intellectual property and innovation in Africa. AFRIPI started in 2020 and has a duration of 4 years. Okay, let's have a closer look at the services offered by the Africa IP SME Help Desk. First and foremost, I would like to highlight that all the services are completely free of charge for the small, medium enterprises who turn to us. Then the action, how does the Help Desk provide support to SMEs in practice? Through transfer of knowledge and a series of other services that I shall introduce to you in a minute. The action of the Help Desk is based mainly on 3 pillars that you can see shown here on at my back and on the screen. First and foremost, the helpline, the most direct first-line service operating by phone, email, or through our website. Secondly, the IP materials, a rather big, vast database of IP materials and publications available on our websites and completely free, available for download, completely free of charge, available for download. Last but not least, the events and trainings. Trainings, of course, can occur on site or in a virtual mode. And trainings, as I said already, events that I will be showing you in a minute. Let's have a closer look to the helpline now. The helpline provides support, is the first line support, the most direct one, to European Union SMEs wishing to obtain general information on Africa and doing business in Africa. The help is provided as assessment pieces as advice in general, completely confidential, to the point, and tailor-made on the needs and on the from the point of view of the help desk client. Our pool of experts may also provide specific advice on the type of intellectual property right that an EU SME would like to register, whether a patent, design, trademark, or geographical indication, for instance. And also in terms of what kind of protection an SME would like to seek in Africa, whether at the national, regional, or international level, for instance. An extra service our pool of experts may provide also concerns specific critical situations that may occur in specific countries of interest within the African continent. I would like to highlight that the Africa IP SME Help Desk does not issue legally binding opinions. It cannot be regarded as a legal support service. Following up with our presentation. Oh, yeah, before I forget, our pool of experts actually commits themselves to providing feedback within 3 working days and operate in 5 languages, which are the 5 official languages of the European Union Intellectual Property Office: English, French, Spanish, German, and Italian. Okay. Voila, the top 3 actually, sorry, of the most received queries by the helpline. In the first place, cross-IP queries, meaning queries about multiple IP rights. Could be combined patents, questions about patents, trademarks, or designs, for instance. Second place, trademarks. And thirdly, enforcement. Following up, let's have a closer look on the queries by IPR and country, thanks to these cake diagrams. If you have a look at the diagram on the left, you will see, as I said earlier, slightly more than half queries concerning cross-IP, followed by trademarks and enforcement. It is interesting to notice that GI ranked 4th, 4% and growing. And while the remaining 3% is divided among patents and plant varieties. If we move to the right, the cake on the right, you will notice that half of the queries, slightly more than half, concerned questions on Africa in general. Then if we move from the bottom in a clockwise fashion and taking the key from top to bottom, we can see Nigeria ranking 2nd in terms of questions. Nigeria, the 2nd most powerful economy of the African continent. 1st. Okay, thank you, Marius. Then followed closely by Kenya, 8%. And well, on par, 7% questions concerning OAPI and South Africa. Okay. Let's move now to the online resources available on the IP SME Helpdesk website. These are, as said, a compendium of IP materials for download free of charge, country and sector fact sheets, case studies, IP guides, and training modules. Country fact sheets, 50 plus, 1 for each African country, plus 1 for OAPI, and a second one for ARIPO. 13 among case studies and IP guides, 10 case studies and 3 IP guides to be precise. Training modules are for the moment 17 completely available for free online and growing. As said earlier, for the helpline, providing specific advice on specific situations that may occur in specific African countries, you can see that some of our material available on the website is customized, is focused on specific situations. See, for example, this case study about customs protection in Kenya and an IP guide on protection at border Kenya on the right-hand side. Then closing, last but not least, training and events. The Africa IP SME help desk participates, takes part in a number of events whose focus aim is to provide SMEs with networking opportunities with their multipliers, with institutions, and also local experts and stakeholders that could be of use for their business in Africa, of course. We participate in the Africa IP SME Help Desk to matchmaking events. And well, events mostly concern, as you can see on my back, countries, IP landscape, regional IP system, industry, and key amendments of paramount importance for their work. Then a few numbers about the outreach of the help desk. So far, we've taken part to 36 promotion and matchmaking events, 37 training events, and we have reached 1,000+ stakeholders so far. On the Africa PSME Help Desk, there are reports available about the events we're attending, including matchmaking events. So a short overview of the next events we shall be attending. On the top left, you can see our event today. And the calendar is growing, of course, events in number. These are our contact information. I am at your full disposal for further information and questions, of course, about how to contact the Africa IP SME Help Desk. Thank you very much for your attention. Thank you.
Thank you so much, Alberto. Building businesses is sometimes very difficult. Sometimes it's a hurdle. Knowing their free support of building business and supporting that is fantastic. Thank you. So for the last speaker before some coffee break, and then we will continue also with some case studies and panel discussions. I will now welcome Marius Schneider, and he will talk about protecting your brands and inventions abroad. And he also wrote this book. Welcome up, Marius. Attorney at law. Yeah. Oh, you want to do it? Yeah. Okay, please introduce yourself.
Thank you very much. So, yeah, thank you very much to the EU IPO and to SWEAC for having me here. I came yesterday from Mauritius, and yeah, I'm very pleased to speak with you today and speak with you here today. And as we are a small group, I would suggest that we consider this a kind of a masterclass, and that you can interrupt me whenever you have a question or, you know, some point you want to raise, because I think we're a small group, so we can do that. I'll introduce myself briefly. I'm a lawyer in Brussels and Mauritius. In Mauritius, I have a secondary office. My principal registration is in Brussels. I'm exercising in IP law since 25 years, approximately 20 years in an African environment. My office in Mauritius is specialized in protecting, managing, and enforcing intellectual property rights. We have 11 people working there in the team, and all of these speak French and English. That's one of the great advantages of Mauritius. It's a bilingual country, and Mauritius, due to its colonial past, has also a hybrid system. So they have common law and civil law in Mauritius. That's the two legal systems of Africa. And that's a great advantage for our legal team to be able to master these two different legal systems of common law and civil law. Yeah, I publish a lot. You mentioned it. So I published together with a South African colleague this book. It's the very first book on the enforcement of intellectual property rights in Africa, published by Oxford University Press. And it examines the situation when it comes to IPR enforcement in all 54 African countries. Very detailed, very practical. Voilà. I do also publish quite a lot. I have shared, I think in advance, a few articles, because I was told there was an interest for medical pharmaceutical counterfeiting. So I've published on the problem of pharmaceutical counterfeiting and how pharmaceutical companies can take action against infringements. I have provided, I think, the introduction chapter to this book, which is available free of charge. So you know, I'm publishing regularly. My next forthcoming publication is on the protection of geographical indications in Africa. This is something very dear to the EU IPO and the European Union. You know, geographical indications are the names of products that, because they come from a certain area, have certain characteristics. And of course, we in Europe, a great part of our products have geographical indications. You are thinking of Bordeaux, Champagne, Scotch whiskey. What are the Swedish geographical indications? Ah, that sounds very good. I'm going to test that. Excellent. Oh, very good. Aquavit Schnaps. Yeah, excellent. Yeah, you see, so this is very important for us. Now, in the office, we work for, I would say, blue chip international clients, a lot of pharma, luxury. We do quite a lot of luxury. You would be surprised. There's a lot of interests in Africa. We do work for the automotive sector, machine tools and the kind. We do advise investment funds when it comes to, you know, doing an audit before investing in companies in Africa. We do advise startups as well as charities. You have asked me, how does it come about that you opened a second office in Africa? I mean, why would a Belgian lawyer open a second office in Africa? Well, we work since 20 years for one of the 4 African unicorns. So a startup company that's now worth more than $1 billion. And when in the beginning we worked for them in French-speaking Africa, and then they asked us to, you know, do more work for them and to come closer to them. And that's when we did open up an office in Mauritius, and this unicorn did relocate their IP holding to Mauritius. I will speak a little bit about Mauritius as well. Because it's quite interesting when you're doing business in Africa to be in Mauritius. And that's how it came about that we opened an office in Mauritius. I'm also the honorary consul of the Federal Republic of Germany in Mauritius. What does that mean? That means that for pro bono, so no pay, I look after the German interests there, Germans in need and the like. There's no embassy, there's no German embassy in Mauritius, although there's a vast German community and 100,000 tourists every year. So it's quite a job, but you know, it's interesting and it opens me up to a diplomatic world. I will speak a little bit about the diplomats. They can help you in Africa. And last but not least, I have a little farm in Senegal. So, you know, my friends say, you have a finger in every pie. Good. So, voila. Yeah, now we're turning to East Africa. And it's indeed, as you just explained, Joachim, it's indeed a vast area. You have compared it to the EU. Okay. You have compared it to the EU. I think the sound is off. No? Okay. You have compared it to the EU. Unlike the EU, there is no harmonization in these countries. So in the EU, we have a lot of harmonized rules, especially when it comes to intellectual property. But that's, of course, not at all the case in this West African community. Although there are certain minimum standards that are imposed by the TRIPS agreement. You have heard probably of the TRIPS agreement. It's all countries that are part to the World Trade Organization need to be part to the TRIPS agreement, which provides for minimum standards for the protection of intellectual property rights. Only least developed countries, and of course there are a few of them in Africa, do not have to apply the TRIPS standards, but you know, by general rule, these TRIPS standards are a minimum that's also kind of applied in Africa. And of course, there's a very interesting development, which I suppose you are all following here, which is the African Free Trade Agreement, which does also provide or will provide for rules on IP. And next to all of this, there's 2 African IP organizations. You have already mentioned them, ARIPO and OAPI. I will explain that, and there's a simplified filing system available in some of the countries. Now, so it worked the first time. Oh, it's my computer now, huh? Okay, thank you. Excellent. So, Joachim, you just explained to us the member countries of the East African community. So I took this, of course, into account when preparing my little talk, but I will expand into this whole area, because if you look at it from a geographic point of view, these countries are part of East Africa, and I will look at what is going on there. Before we do that, I'd like to explain to you about the two African IP organizations that are active in Africa. So we have on the one hand the OAPI. OAPI is an acronym for Organisation Africaine de la Propriété Intellectuelle. As the name already says, you know, African IP organization in French, as the name already says, it's essentially a West African Francophone, French-speaking organization that has 17 member countries. So you see here on the map, they're all in West Africa. So there's, you know, powerhouses like the new African champions of Côte d'Ivoire, Senegal, they're a member here, and also the Comoros. That's the only East African country that is part of OAPI. OAPI exists since 1977. So it's older than the EU IPO. I'd like to highlight that here. And they have a system of unitary rights, which means that you have one right, intellectual property rights, that's valid in all of these 17 countries. So one trademark, one patent, one design that you know, you can get obtained there. It's very similar to the system in the EU, where you can get unitary trademarks and unitary designs. The difference is that in the EU, national rights continue to subsist. That's not the case in OAPI. And OAPI goes much further because they have unitary rights in other sectors, you know, plant variety rights and the like. So it goes further than what is the case in the EU. So that makes it interesting. Also, there are uniform rules on unfair competition law. So that's very important because, you know, a lot of times in Africa, actually, we have this problem of unfair competition or passing off, that they kind of imitate your packaging without copying your actual trademark, but it is this absolutely the same look and feel. That's one of the big problems in Africa. So there's rules provided on that. And very recently, the OAPI has added rules on customs enforcement of intellectual property rights. So what is customs enforcement of intellectual property rights? We all know that most of the counterfeit goods, they are not produced in the country where they are sold. Most of them come, actually, if you look at the statistics, we don't want to do any naming and shaming here, but if you look at the statistics, most of them come from China, from you know, East Asia, and they enter, you know, our markets, the markets in Africa, so they have to pass a border. And at the border, customs is competent to stop suspect shipments of suspected counterfeit goods, inform the right holder so that the right holder can undertake actions to take this to a court or initiate a criminal action or even settle it amicably with the owner of the goods. But this is called, you know, customs enforcement of intellectual property rights, so customs recordals. This is now available in OAPI. It's not yet functional in all countries, I have to say, but it's in the law, and they are making efforts, and I'm quite sure that the EU, together with Afripi, is also doing efforts to push this further, because it's in the absolute interest of, you know, European and international companies. So this is a brief overview of the OAPI. I'm not going to go into further details because, of course, it's in West Africa and we are speaking here about East Africa. So let's move to East Africa. There is the African Regional Intellectual Property Organization. It is established in Harare, Zimbabwe. That's their headquarters. And they exist also since the 1970s. It's been created by an agreement called the Lusaka Agreement, and there's 22 actual member states to this. ARIPO, R-I-P-O. Now, the fact of being a member state does not mean that you can actually file your rights through the ARIPO in these countries. that's important. The countries actually need to be part of a protocol on the specific IPR rights. And there's protocols on trademarks, there's a protocol on patent and on traditional knowledge. For us, I think SMEs, as you have rightly pointed out, the most interesting protocol is the protocol on trademarks. That's the so-called Banjul protocol. And that provides for a simplified application procedure for trademarks in 13 East African ARIPO countries. Now, how does that go about? You file one single application in which you can designate, kind of cherry picking, if I may say so, designate countries in which you want to obtain protection. So one single application, you can choose the classes, products and service classes in which you want to obtain protection. You know probably that for trademark purposes, goods and services are classified in 45 classes. So some companies, they say, okay, we want a broader protection in some markets and a less broader in other markets because, you know, we're going to first invest these markets and then others. So, you know, you can pick and choose in this Banjul protocol between 13 countries. They are listed here, essentially Tanzania, Mozambique, Zimbabwe, Botswana, Namibia, but also Uganda, and here is it Liberia, I think so. Huh? So, you know, this is how it works. Now, these 13, okay, so, and then you file one single application with the ARIPO organization in Harare, Zimbabwe. That is then examined there. And once it's examined, it is passed on to the national intellectual property offices of these member states, who can then also examine, publish for opposition these applications. And then once you obtain your trademark rights, they are equivalent to national rights. But the nice thing is that there's one renewal procedure, so it's quite handy and it's easy and it's less expensive than to file national applications in all of these countries, okay? Now, there is always discussion on the validity of these ARIPO trademarks. Huh? A lot of lawyers, companies are reticent. They say, ooh, what about the enforceability of these ARIPO trademarks? Where does this reticence on the enforceability come from? Well, all of these countries are common law countries. Huh? The English-speaking East African countries are essentially common law countries, and so they have what is called a dualistic system. What does that mean? It means that international treaties have to be domesticated into national law to be applicable. So it means that an international treaty, like, for example, this Banjul Protocol, needs to be passed into a national law for it to be applicable in these common law countries. And some people say, oh, but some countries have not domesticated this Banjul Protocol, and so there may be an issue of enforceability of these trademark rights, okay? So I would like to reassure you, I would say that in practice, when it comes to enforcing ARIPO trademarks, in practice, I have never in my practice, and we are doing a lot of cases there in this region, I've never come about an issue where the courts would have said, no, these trademarks are not enforceable. I think it's maybe a push to sell more expensive, you know, national trademarks. So in my point of view, there's no practical issue. Now let's look at it from a theoretical point of view. There are a few countries, Botswana, Malawi, Mozambique, Namibia, Sao Tome and Principe, and Zimbabwe, who have actually domesticated, so there's no issue there at all. Lesotho, Liberia, and Uganda, they have either provisions in their law saying that all international treaties are to be considered as domesticated, or there is a court decision holding the validity of an ARIPO trademark, and there is only remaining doubts in Cape Verde, Eswatini, the Gambia, and Tanzania. So just to say to you that there's doubt in these countries, but de facto, in practice, there has never been any issue when it comes to enforceability. So that concludes my little introductory talk to these two international IP organizations that are active in Africa. I would now like to speak briefly about the countries that are member to the Madrid system in Africa. Do you know all what the Madrid system is? No? So we need a word of explanation here. The World Intellectual Property Organization, which is a UN body, has actually come about with simplified filing systems for their member countries of what is called the Madrid system. It's made up of an agreement and a protocol. It's very complicated. I'm going to go into details, but how does it work? Actually, it is like that if you have a trademark registration in your home country, so say you're a Swedish company, you have a trademark registration either in Sweden or in the EU, then you can build upon this home country registration and extend it to other countries that are part of the Madrid system. And again, it's a simplified filing system where you can pick and choose countries that are part of the list. There's now more than 100 countries that are part to this Madrid system, and there's 40 African countries, including one of the IP organizations that I was talking about, which is actually the OAPI. That's all the red zone. So the red you can designate by filing an international application. It's the same as the ARIPO trademark. So you file one single application through WIPO, the World Intellectual Property Organization in Geneva. It's all electronic now. And the WIPO examines your application. And once it's been tested on examined on formal grounds, they will pass on your application to the national offices that you have designated, national IP office that you have designated in your international trademark application, where the member states will then have a maximum of 18 months to examine and issue a refusal of the trademark. They can get a little extension if there's an opposition procedure, but essentially within 18 months, you will know whether there is a problem with your trademark. And the good news is if you don't have any news in the 18 months, then your rights are granted. So it's a great system. It's much, much cheaper than filing nationally. So companies do really rely heavily on the Madrid system. The EU is a member of it. The EU IPO is a member of it. So it's great. Once you obtain the rights, they are equivalent to national rights. So they can be enforced like a national trademark. Again, there can be some discussion in these dualistic, common law countries on the enforceability. But here again, I have never come across an issue where an international trademark registration would have been held to be not enforceable. Now, so you can designate 40 African countries through an international application. In East Africa, that's Kenya, Madagascar, Malawi, Mauritius, Mozambique, Rwanda, Zambia, and Zimbabwe. And in the rest of Africa, you see here, there's big powerhouses, like Algeria, Ghana, Egypt, Kenya, makes it very convenient to, protect your trademark there. I can only say, do it as much as you can. And in all the other countries, all those countries that are gray on the map here, what do you have to do? Well, there's no simplified filing system available. So that means that in these countries, you have to file national trademark applications if you want to protect your rights, going to the national offices and following the national procedure. So let's look at West Africa, that's essentially the case for Ethiopia, Djibouti. I will talk about Djibouti, South Sudan, DRC, Angola, also South Africa, Nigeria, of course. So, Nigeria, the number one economy, they're disputing a little bit with South Africa. There has been a huge devaluation of the Naira in the last few weeks. You've seen that. The economy is struggling there in Nigeria, but, it's really the African powerhouse. But in a nutshell, so the gray countries, there's no simplified filing system. There you need to go to the national offices to obtain protection for your trademark. Now, I will just dwell into a few countries. I will highlight things that I think are notable facts, okay? I cannot talk about, all these countries in East Africa in detail. You have the fact sheets. Really, I recommend that if you have the slightest, doubt, hesitation, you want to find information on what's going on in relation to IP in Africa, these fact sheets, they are very, very well done of the IPR SME Helpdesk. So really, my recommendation is look at them. You will find detailed information there. I'm going to only highlight a few things for every country, and then I'm very happy to, take also questions if you want. As I said, you can interrupt me. So first country we're going to is Kenya. Kenya, you see here a nice picture of Nairobi. Nairobi is one of the only cities in the world that has a game park. In the city, when you fly over and when you land at the airport, you fly over the game park. So that's how these incredible pictures, come about. Now, Kenya has very modern IP laws. They have a very well-functioning IP administration, trademarks, patents. You can all file that with KIPI. It works. It's examined. So yeah, great system. Kenya also has courts that do understand intellectual property rights issues because, not every court, in Europe, we have specialized IP courts. There's a EU directive, making it mandatory for EU member countries to designate specialized IP courts so that judges have experience and can build up experience in IP matters, which are technical matters, complicated for a judge to understand. And Kenya has also judges and courts that understand IP matters. They, by the way, is one of the first African countries to seriously consider the introduction of mandatory specialized IP courts. So, very good. Kenya also has a good enforcement practice through customs. So a customs application for customs enforcement is possible in Kenya. Sorry. Now, there's something else that Kenya has that I would like to highlight, which is the mandatory recordal at the ACA, the Anti-Counterfeiting Authority. What does that mean? So it is mandatory for foreign right holders to register their intellectual property rights at the Anti-Counterfeiting Authority. The idea behind this is to make Kenya a counterfeit-free country. That was their ambition. So that's the declared aim of the government, meaning that you have to, as a right holder, register your trademark with the Kenyan Intellectual Property Office called KIPI. And then once you have obtained your registration there, you need to mandatorily register as well with the Anti-Counterfeiting Authority. That applies to every good that is imported into Kenya, irrespective of the place where the IP is registered. That is a very interesting notion. That means that even if you don't have a registration in Kenya, you would theoretically, or actually by law, have to register your rights at the Anti-Counterfeiting Authority, and non-compliance of registration is a felony. So you can be subject to criminal prosecution if you're not doing it. The law also provides for the fact that unbranded goods in Kenya are prohibited. You can, of course, debate whether that's a good idea, whether in Africa, where consumers don't have necessarily the means to invest in branded goods, whether it's a good idea to prohibit unbranded goods. But, it's not our choice. Now, how did this come about? There was a three-phase approach implemented in Kenya. The first phase was the development of a database, so an electronic database for all intellectual property rights in Kenya, and the second phase was the mandatory recordal on that platform. So right holders needed to file an application. There is a fee that comes with this filing of this application, so there's an official fee for that. You need to provide quite a lot of documents. You need to provide certified copies of your registration certificates, trademark registration, patent registration. So there's no link between the IP office and the ACA, as is the case in Europe, where for our customs recordals, there is a link between the official EU database and the customs system. Well, that's not the case in Kenya. So you will need to provide certified true copies of all your registrations. So it comes at a cost. You will have to, if you rely on a local colleague for the filing of the application, you need to provide them with a power of attorney that needs to be legalized. And it's all very complicated, burdensome. You need, as a company, to provide also quite a lot of information. And, it's, of course, a very ambitious project to make an African country counterfeiting free. But there's a lot of criticism as well, because, especially European economic interest groups say, well, it's just another way of imposing costs on doing business, levies. And de facto, we see, unfortunately, that there's not a lot of seizures there in Kenya. So you would have, of course, expect that if you have a mandatory system where you need to record your intellectual property rights with an anti-counterfeiting authority, that this authority would then go around the whole country and do seizures with all the information they have. But unfortunately, that does not seem to be the case. It's not become more proactive since it's mandatory to register there. And that's at least my impression and the impression I gather from my colleagues. And so, one can discuss whether this is really an effective measure. I have, for those who are really interested in this subject, I think I provided an article on this whole procedure. You have it in 15 pages, all in great detail. We're moving to the Democratic Republic of Congo, vast country, and great place to do business. What I would like to highlight is that the system there of recording trademarks is so and so. It's very difficult. The trademarks have to be applied for and recorded directly with the Ministry of Commerce. The trademark registration certificate is signed by the minister himself, meaning that it's can be a very long process. Now, interestingly, using an unregistered brand constitutes an unlawful assertion of ownership thereof. So if you use a brand without, or a trademark without having a trademark registration in the DRC, well, you can be fined for that. Interestingly, also, slogans are registrable in DRC. So there's a special register for slogans. And we recently had a company that was fined there for not registering their slogan. So the authorities came, looked on their packaging, said, oh, you're using a little slogan there to promote your products on the packaging, and you haven't registered that slogan, so we're going to fine you now. I have asked for the basis of this. Of course, using an unregistered mark, that's true, is an infringement of the law. Slogans, yeah, voila. Something to keep in mind, just if you're selling products there with a slogan, well, probably a good idea to register it there. Trademark applications, like in all countries, must be published to be opposable to third party. The only problem is that if you file a trademark application with the registry, you will obtain a registration certificate at the end of the process. That may take years. It's very important that you or your lawyer diligently follows up on that registration procedure. Otherwise, it takes years and years. So you will get a registration certificate, but the ministry will not, or the office will not provide for the publication. So you will have to arrange that yourself. You will have to go to the Gazette and publish your trademark yourself. and pay for that publication. Otherwise, your trademark is not opposable to third parties. So that's quite important because it's only one of the only countries in the world that I know of where you have to do this job yourself. At the EU IPO, of course, your trademark is published for opposition automatically, and there's no discussion about this. Well, in Congo, you need to arrange it yourself. There's also no opposition procedure that's provided. What do I mean when I say opposition procedure? When you apply for a trademark, then the office will publish your trademark so that third parties can oppose to it. Say you have, as a company, you have prior rights. Somebody comes and files a similar trademark or the same trademark. Well, you can oppose to it, and that way, in an administrative procedure, prevent the registration of the trademark. Well, that administrative opposition procedure does not exist in the DRC. Okay, we go to Tanzania. Tanzania, you would probably think that Tanzania is actually one country, and of course you're right, but Tanzania, for IP purposes, are two countries. Actually, there is mainland Tanzania, the former Tanganyika, and there is the island of Zanzibar, and these two have separate IP registries, okay? So that's something that has a historic background. By the way, no, I don't know. The same existed in Morocco. You had also two trademark registries in the past for Tanger and Agadir. That is now, Casablanca, sorry. Casablanca and Tanger, that's now finished. But in Tanzania, important, keep it in mind, there's two different IP systems because it's a federal state, and a trademark in one country does not, in one region does not extend to the other region. So if you want full protection in Tanzania, you need to file in Tanzania, but also in Zanzibar. Now, to make it all more interesting, you would think it's done on purpose. There's quite a lot of difference between, when you apply for a trademark, between Tanganyika and Zanzibar. In Tanganyika, you can file online and you get an electronic certificate. In Zanzibar, you can only file on a paper application and you get a paper registration certificate. Now, that makes it all even more funny. The registration in Tanganyika is valid for 7 years after the filing date and can be renewed for 10 years. In Zanzibar, the registration is valid for 10 years from the filing and can be renewed every 7 years. So, it's really, I mean, really, you wanted to do it on purpose, it would be, yeah. So I'd like to, I wanted to highlight this to you. Yeah, because I thought it was interesting. And so if you want protection, full protection in Tanzania, you need to file two trademarks. We're going to move briefly to Madagascar. What I want to say about Madagascar is that the IP office there does examine a trademark application for both formal and relative grounds. What does that mean? It means the IP office will first of all examine whether your trademark is distinctive, meaning that it's not descriptive, not against public morale and the like, but it will also examine your trademark to see whether it is in conflict with some prior rights, prior existing trademarks. That's what's called the examination for relative grounds. If the IP office issues a refusal of your trademark in Madagascar, there's no appeal procedure. You have to go to court to contest that refusal. Court actions in Madagascar are extremely long, burdensome. You can count on 5 years in the first instance. So, this makes it all complicated. There's also no opposition procedure, and all of that has led to the fact that there's a lot of trademark trolls active in Madagascar. So, because, registering a trademark in Madagascar is not very expensive. You pay a few ariary to the office, and then your trademark is examined, you get it. So there's a lot of trademark trolls that went ahead and registered foreign brands in Madagascar, and we're just sitting on these certificates waiting for the companies to come into Madagascar. And then, it was necessary to file a court proceedings against these guys. And you know, it's a long procedure, as I said, and so many right holders, when they want to come into a market like Madagascar, they just prefer to settle and pay something, and that's what these trademark trolls are speculating on. So this is something you need to know, meaning that if you are interested in Madagascar, be on time, just to be sure you have your trademark there on the register when you want to start to operate. I'm turning to Mauritius, and this is really indeed how it looks like there. So it's really, really nice. I'm turning to Mauritius only to tell you that, of course, it's part of, not part of your interest countries, but it's part of that region in East Africa. And it's a quite interesting jurisdiction for several reasons. It has a, let's say, a very nice tax rate of 15% plus 2% of CSR. Export manufactured goods are only imposed with 3%. And most interestingly, so it has a nice corporate tax rate, let's put it like this. And very interestingly, Mauritius has a very good network of non-double taxation treaties and investment protection treaties, meaning that if you have a Mauritian company that invests into Africa and something arrives to these investments, well, the investment protection treaties will give you a certain guarantee to recover at least part of your investment. So that makes it very interesting. Same non-double taxation treaties, a lot with African countries and with European countries. So making Mauritius really an interesting jurisdiction. In terms of IP rights, Mauritius is interesting. Why? Because there is a 8-year tax holiday for companies that invest in IP rights, patents, designs, and yeah, that makes it quite interesting to set up in Mauritius. It's possible to have 100% foreign ownership there. So then I'm moving to Uganda. Uganda, I don't have a lot of things to say on Uganda. What I find interesting is that their intellectual property office is actually very, very active. And unlike what is the case in many, many other African countries, they are even proactive because they have a chat function on their website and you can actually ask them questions. So before filing a trademark in Uganda, you can actually chat with the IP office and say, hey, I want to file this and that trademark. Do you think it's distinctive? Do you think, how can I go about? So I think, this is quite a, I mean, you have, of course, not exactly a chat, but you can get some advice at the EU IPO, of course, in Europe. But for an African country, this, I think, is something worth noting. And then I just want to conclude a few words on Rwanda and Burundi. In Rwanda and Burundi, it's fairly easy to obtain trademark registration. In Rwanda, it'll take approximately 6 months to get a trademark. In Burundi, it'll take only 5 weeks. Now, again, you have to be a little bit careful because in Rwanda, trademarks are not published for opposition. So there's no information to third parties. And there is no actual opposition procedure, although it's provided for by the law. In practice, it doesn't work. So third parties cannot initiate an administrative procedure to object to the registration of a mark, and the same in Burundi.